Hello, welcome back to the Mission Mediation podcast. This is the fourth episode, and we're really excited to bring to you another fantastic panel to discuss once again a provocative topic. Are lawyers actually relevant in mediation? I'm Jonathan, I'm going to be your host today. I'm also a mediator and a partner at the Pact. I'm joined by today my co host and a mediator himself, Nishant Doria, and we'll be together anchoring this conversation at the Mission Mediation podcast, brought to you, of course, and produced by the Pact. We've got two fantastic guests joining us on this podcast. I'm really raring to get down to those fantastic experiences they're going to be sharing with us. But if you are not familiar with our work so far, the Pact has been in this business now in mediation for the last 10 years, founded in 2015. We've spent a good amount of our time with lawyers, with young lawyers, experienced lawyers, initiating them into mediation advocacy and mediation as a skill set. And it's been our privilege to work with close to around 16,000 young lawyers since a decade now. This has been a fantastic journey. We've got a chance to mediate on some interesting cases, being part of people's lives and make their lives easier and bring closure and peace. And collaborative justice is something that we really, really hold close to our hearts. And it's a privilege to be part of something like that. And today's conversation is going to be focusing on the role of a lawyer in mediation. And we have actually spent the last couple of years kind of highlighting the role of the lawyer in mediation to explain that it's not as simple as it seems. It's not about just taking off the cloak of a litigation lawyer or an arbitration lawyer and just saying, I can just walk into a mediation and without any preparation. It is, of course, informal. The process is informal. It's not similar to arbitration or litigation, as most of us know, but at the same time, it requires preparation. And we're going to try and dive deep into what kind of preparation that means on today's call. So if you're joining us live, wherever you are, good morning, good afternoon, good evening. And thank you so much for joining us live on LinkedIn. Please drop in a message. Tell us where you're joining us from. If you're watching this on YouTube, once again, you can say hi and tell us where you're joining us from. And if you're watching this on record over the next few days, once again, welcome to the Mission Mediation podcast. As I said, we've got two fantastic guests. I was going through their CVs and I realized I'll need at least 45 minutes to introduce each of them. So that's not happening today. And we're going to keep it very, very brief. But I don't think either Tat Lim or Raj Panchmatia requires an introduction. But for those of you who are completely unaware of who they are, let me try and brief you with a quick introduction to both Tat and Raj. So Tat Lim is an experienced international dispute resolution practitioner based in Singapore. In fact, Tat's traveling so much, I wouldn't be surprised if he's actually joining us on 35,000 feet up in the air right now. Though I think he's just landed in Singapore, so let's say he's in Singapore today. But he's an international mediator, traveling mediator, who's a who's who legal global elite thought leader for 2024. He's a solicitor at the Supreme Court of Singapore and also at England and Wales. He's a founding mediator at Maxwell Mediators and the chairperson of the International Mediation Institute, or the IMI. He also has significant roles as a board member at the Singapore Mediation Center and the International Bar Association. And of course, we're very fond of him because he's a lead trainer at the International Mediation Advocacy Training that we have the privilege of co-training with him. Tad, thank you so much for making time for this conversation on a busy Thursday evening.
Thank you. Thank you for having me.
All right, let me introduce you, Mr. Raj Panchmatia, to you. He's a partner in dispute resolution at Ketan & Co. He has advised clients on a wide variety of claims under the Indian arbitration laws, SIAC, LCIA, ICC, UNICITRAL, and HKIAC. He's an accredited semi-mediator and an empaneled mediator with the SIMC in Singapore. He's an arbitrator empaneled with SIAC and HKIAC. He's a ranked lawyer in dispute resolution by Chambers and Practice and a recommended key lawyer in dispute resolution by Legal 500. Raj, thank you so much once again for making time on a busy Thursday evening.
Thank you. Thank you for having me. Thank you.
Awesome. As I said, these introductions are so brief. We can't really cover the experience that we have in the room today. So I'm going to dive straight into it. Without further ado, I'm going to hand over the mic to my co-host, Nishant, who's going to try and break down this very provocative question. Are lawyers relevant in mediation? Nishant, over to you.
Thank you, Jonathan. I think, over the last couple of sessions that we've had, we've kind of
kind of come to a point where we know that lawyers are actually relevant and important to mediation. But what is even more important is showcasing that through success stories or real life examples, which is where I'd like to start, Mr. Panchmatia. Um, I'd love for you to give your thoughts on whether lawyers are actually relevant in mediation, and if we can know that through maybe a case or cases that you were a part of.
Thank you, Nishan, and thank you, Jonathan, for having me. Thank you, Pact, for having me on this show, on this podcast. I think lawyer is one of the key elements of the mediation process. While you have the mediator at one end, you have the parties at the other. And I think a lawyer plays a very good bridging role between the two, uh, especially if the lawyer himself believes in the process of mediation and he's trained and he knows that how the mediation process actually goes through, because many a times we've seen lawyers use mediation as a tick box approach because they're required to complete it. But I think it's important that lawyers believe in the entire process and feel that yes, mediation can actually bring a resolution and get the clients what they want. So I think it's very important to understand clients' interest, speak to the clients that are they willing to go into mediation, what will be the impact of mediation on the client and what that they want to achieve, uh, what are the legal issues that you need to take care of, how far do you want to go into mediation, what is that you can give up, what is that you cannot give up, what is that you need to protect, but at the same time try and get a resolution which is commercially viable for you and for the other side, because it's not just one client who succeeds and goes out of mediation. I think it's both who should feel satisfied that they've got something out of it and they've gone back happy.
I
If
am
only one person was to go happy, then it's not, I would say, a settlement in a way which has kept everybody happy. So
I
I
think
think
I'm in complete
mediation is very
agreement with you,
important.
especially when you say that you have the lawyer's role is very important, not only during the mediation or negotiation, but prior to that as well. Trying to understand the matter, trying to consult or counsel the client as to why this is fit for mediation and strategize with them. So, has there been a situation with you where the client was not or was hesitant in going for mediation, and you had to play that role to convince them, and how did that go?
I'll be honest, we see that very regularly, especially if the matters are coming from the court. You will see them very, very regularly that they feel that it's just tick box approach. Let's complete it. Let's get done with it. We don't want to waste too much time in mediation. But when you actually sit down with the client and you tell them that how this can actually help to get the matters resolved, I think they see the benefit of it. They see what value a good mediation can bring. And to have a good mediation, it's equally important to select the right mediator, to have lawyers who understand mediation in the room. Many a times you may not get people who are trained in mediation, but if you have a good mediator who's trained, he will bring about a, a lawyer who's not probably trained into mediation to explain him the entire process, bring him along, get him along to ensure that the entire process is run smoothly. It's very important that many a times we see in a cross-border disputes, there have to be cultural alignments with the because the parties are from two different jurisdictions, different cultures, and it's very important that a mediator who's there and the lawyers involved understand that there will be cultural differences and nuances, and you need to keep those in mind while
Absolutely.
dealing with the process.
Correct. I think the lawyers can make a huge impact even in bridging the gap between both the parties, as well as for the mediators to understand the parties better. So again, if we can use some case studies or an experience that you had. Maybe we could start with the facts of it, and then I'd love to question you on the experience you had and what was the process that you followed.
So of course, I'm happy to do that. As you know, the process is entire confidential, so I've kind of mixed and matched some of the
Yes.
facts because I can't give you the full facts. So we had a client, and we were for an Indian company. We had a client who was in the manufacturing sector, was supplying materials to a party in Europe uh, on a regular basis. Something happened, and the contracts got terminated. Now, it was a big contract for my client, uh, we, and we had to initiate some process to ensure that the contracts are not terminated in the manner in which they are, and that if they are, then the client wanted some some damages for actually the investment that he had done to run those contracts in India. My clients initiated initially a proceeding in Hong Kong. Uh, Now, the Hong Kong courts require that before you go ahead with the proceedings in Hong Kong, you need to go through a mediation process. Now, at that point in time, we were not very sure what this entire process would be and how this entire process would run because it was cross border, commercial disputes, suits been filed in Hong Kong. Where will the mediation be? Who the mediator would be? Uh, Fortunately, court appointed a very good mediator uh, based out of UK. Uh, we had multiple sessions of mediation in Europe. Uh, Other side was from Europe. We had no problem. We had a very good mediator. We had mediation in his office in Europe. Uh, it was We filed our opening statements. We had sessions.
I'll just come in here before moving to what happened in the mediation, right? I just like you throw some light on how did you, as the lawyer representing the parties in the mediation, how did you work in terms of prepping the client and strategizing for the mediation session? Did you have to spend any time, or did we just directly meet at the mediator's office and start the mediation?
So we had to, first of all, we had to convince the client that
Mhm.
why go for a mediation? Because anyways, it was a cross-border dispute. My client was anyway spending a lot of money initiating proceedings in Hong Kong, and from there we had to go to Europe for mediation. So there was another cost involved and a substantial cost involved. So first of all, it was important to convince him that yes, this will be a good process. At least let's participate in right earnest. Had to explain him what to how far we will go in the mediation, how much can be disclosed, what can be disclosed, and that this will be all be confidential and cannot be used then going back in courts. So it was important that confidentiality was maintained. The clients was very concerned with that. So it was very important to tell them. We also had to tell them that these are the things that we cannot let go of because if for any reason mediation did not succeed, we had to ring fence certain aspects which we had to protect. So we had to sit down with him, explain him what we can do, what we cannot do. If we were to compromise, what was the amount that we were looking for, and what was the justification for that amount. We had experts helping us quantifying damages. So we did create a proper documentation to show that if we are asking for a certain amount, why are we asking for a certain amount, and what is the basis of that amount. So even if we had to, assuming we had to disclose it to the mediator, we knew that we had certain things which were actually quantifiable and reasons behind it, and why our clients felt so strongly about these kind of claims. So we had to prepare, we had to explain, we had to tell them the certain claims you may or may not get. So we had to also kind of temper his expectations to tell him that these things you may not get in a mediation, you may not succeed on these parts. So you have to go in with an open mind that this is the thing that you may get, this you may not get, and are you okay to live with these things if you don't get? Because you're going to get a lasting peace in in your in your disputes. You don't have to go through the entire disputes, then eventually see what's going to happen. So might as well resolve it now rather than go through the entire process where you'll end up spending so much money, so much time. Is it worth it?
And all this was even before the mediation actually started. So you said there was the convincing phase where you had to convince the clients. So that's where a lawyer plays a big role, because ultimately you are his first point of contact in a dispute. Once they're convinced, then you're talking about strategy. What how what and how far you'll go, how much you'd want to disclose, the options, the justifications, and as you pointed out, most importantly, which is that basis for asking, what they are. So all this preparation actually went into the mediation, the pre-mediation stage, if I have understood correctly from
Yes.
you. So go ahead.
No, absolutely. What you're saying is right.
Nishant, can
Uh,
I just come in quickly, if you don't mind, before Raj moves into the next part? Raj, you spoke about expectations, right? Just make sure that you're balancing the expectations of the process. Did you also talk about expectations of the mediator, what they can expect of the mediator, and what they can expect from you as a lawyer? Because suddenly you're not representing them in a litigation scenario or an arbitration scenario, but you're representing them in a mediation scenario. So did you also like kind of share with them what their expectations should be of you and also of the mediator?
So yes, I think it is important to make your clients aware as to what a mediator would expect, or what you should expect from a mediation and mediator, and how much and to what extent will this discussion go through. And it- because you as a party, you will also have to come honest and disclosing as to willing to settle the matter before the mediator. It can't be that you just have your position and you're not willing to move away from your positions. There has to be a way in which you come across that you are willing to compromise, but at the same time you have certain no-go areas. So it was very important to put that in clients' mind. You can have free discussion with the mediator when the mediators call you one-on-one with the parties, or one-on-one with the mediator. It's important to have frank discussions. Let the mediator know what you feel and why you feel in a particular manner, and the clients were fine with it. Like initially when we suggested an idea of mediation itself, the clients first had a question: why mediation? Why am I wasting my time? I've hired you to litigate, not to mediate. I've come to you, you're a litigator. I've come to you for litigation, not for mediation. Why are you asking me to settle? Because that time the tempers were very high, right? The parties were at loggerheads with each other. So we had to temper down that and explain them that let's give it a shot. If it works, great. If it doesn't work, we'll see. We're back to the courts. There's nothing, no harm done.
Interesting. You say that, and so we've spoken about how you deal with your client. Um, I just like to ask before we wrap on this experience, how is it that you deal with the opposing counsel, especially in a case where you are in different continents, it's cross border, there might be cultural differences. How do you deal with them, and how do you interact with them in such a situation to make it more of an amicable process as opposed to what we have in courts?
So for us, it was good to do a session when we met for the first time before the mediator. In that session, we tried to break the ice by having a light-hearted discussion to make things lighter. We had good discussion generally about how the matter is, where it is. We did not try to blame anybody in the first session, because the moment you started doing that, At least we thought that the moment we started saying that this is wrong, that is wrong, they would tighten up their position, and then the discussions may not have any beneficial impact. So we tried to keep it as factual as possible. I think that brought in a lot of comfort on the other side. They also realized that we were not there to just make blame games, and we were there to actually find solution. Maybe there were some facts which they perceived it differently, so we let them say those facts before the mediator. So that also gave them an opportunity to explain to the mediator that how they saw things a little differently, rather than blaming each other.
So I think in this case, what if I understand correctly, you're saying that the initial time spent, initial session in terms of breaking ice in the discussion actually led to um, a platform where you could, or the opposing parties could share slightly more freely, and then use the mediator as well, which I think is very very much important. And as final question on that, what was your biggest learning as far as this specific case was concerned? Did anything strike you in it? Did you take back anything that sticks till date?
I think the way the mediator actually did the entire mediation was very impressive. We tried to complete the entire mediation in 2 days, right? And it was intense. We spent around 16 to 17 hours on day one in the mediation.
Oh wow.
And the mediator actually ensured that we didn't get out of the room before we had certain agreements in place, right? And by the end of day one, by and large, we had agreed on most of the issues. There were certain issues which did not get resolved on day one. Even on day two, we had an issue. There were two issues which remained pending. So we thought that the mediation may not actually yield a positive result. But the most interesting part was the day we left. Next day, we parties actually spoke to each other again, and they agreed on even those two issues. And then we reached out to mediator and said, now we've got the settlement, can we close it? So while they could not make it in the presence of the mediator in the 2 days, but a day later we managed to do it, because parties then got time to rethink and re-see their positions, and whether it was beneficial to close it or to litigate. But I think those 2 days of intense mediation that we did, I think that kind of gave clients a very good insight into their own matters, own issues, own positions.
Yes, I think that's very important. It's very, very important to give time. And people, see mediation as a 1 hour, a 2 hour session. No, it can go on for 8 hours, 10 hours, 12 hours. And that's when you're forced to even think on your positions and interests, as you said, Rajan. And quite a few interesting points that come out of it, which is where Tat, over to you. Is your case also somewhere that the mediator kept you in the room for 16 hours, or was your experience slightly different? Would love to know the facts of the cases that you have in mind.
Well, every week, I might have one or two cases where either I'm involved or my juniors are involved. Mediation, I think, at least in my part of the world, Singapore has embraced mediation for a long time, almost 20 odd years. And so most of our cases, invariably, either, whether it's a litigation or arbitrated case, it would go at some point into either a mediation process, or if not, at least direct negotiations process. I mean, there are so many cases, but perhaps one that I could think of, which would almost like epitomize the sort of cases we do for cross-border, would be we represent a Singaporean company, and the UK lawyers represent a UK company. And after the process had reached a point where parties were filing proceedings in the UK courts, we agreed to arrange for parties to mediate the dispute. We selected a mediator from CEDA, and then we went online to mediate the dispute. The mediation lasted probably almost 10 hours. There wasn't a settlement, but within 3 months after that, we settled, which is not an uncommon experience for me. Right. I mean, the other case I thought I want to just put out for listeners is there are a lot of domestic cases that we have, and the typical sort of trajectory of a domestic litigated case is at some point after discovery, parties do consider mediation. In the state courts, invariably you'll be invited to consider mediation as a presumption of ADR effort. But in cases in the Supreme Court, we parties, and I mean through their lawyers, usually would be very receptive to mediation, and we would get into mediation. And typically in Singapore, domestic cases would have in-person mediation. And during those mediations, you find that almost close to right now 60% of mediated cases settle on the day itself. And the others, many of those would settle after. So that's the experience, I think, of most Singaporean practitioners.
Interesting. So the case one you meant, the first case that you shared was of an online dispute, as in the mediation was taking place online. Was this case where also you were sitting in different places, as compared to your clients as well, or were you in the same vicinity? Because I'd love to, if you were in different places, I'd love to know how do you deal with that, and how do you prep the client, and how do you communicate during the mediation?
Yeah, so my preference, both as counsel and as mediator, would be that parties, as much as possible, put themselves together. And certainly, as a mediation counsel, uh, unless the client is inconvenienced and they prefer not, we will huddle in the same conference room while we participate in the mediation. So within the room, my clients and my colleagues will all be seated together. So that at any point in time, if we need to break out into our own discussion, we can switch off the video, and we can have a conversation even while the mediation is in progress.
Okay, so here in this case, you all were together. So when that happens, what is the process you follow to prep the client?
Right. Well, again, no secret, I think, for us. We usually have to spend less time persuading the client to mediate, partly because, again, the landscape here is very mediation receptive. But on occasions when we've had to persuade the client, usually it's not too difficult. I think in this respect, people do know that I practice a lot in the ADR process, and they usually, if they wanted to do problem solving, they would choose a firm like ours. Naturally, I mean, if they wanted a firm that simply isn't too mediation, how do you say, friendly, they might choose another firm altogether. And there are firms out there that would be very litigation and arbitration sort of skewed in the way they address disputes. But the second stage after that is really to sit down and prepare the client for the mediation. And I usually have prepare them to meet me for at least 2 hours, 3 hours, where I walk them through a list of things. And I think it'd be easier for those of us who have not done this before, your listeners, to kind of like maybe show what that might actually look like in terms of slides. So can I just take a minute and show just what a presentation would look like from my
Yes,
firm to the client? Right. So
absolutely.
are you able to see?
Not
Um,
yet, but I think you'll have to use the present button and get it up there.
yeah, I've done that. And if I stop sharing again, I use present, share screen, and I can see, I select the window and I say share. You don't see
All
it?
right. Yes, I think. Oh, sorry, it's on my end. I got to put it on stage. Give me a second. There you go.
Okay, so for instance, right, this would be I didn't create this presentation for us. This is something I do for cases where I need to prep the client because they may not be too familiar. But you see, this is the agenda. I want to talk to them the difference between mediation and litigation, help them understand the role of the mediator, the process, help them understand the kind of bargaining that will go on, help them understand how we should prepare, right? And these are slides that you often find in mediation training or negotiation training, but there are things which helps me to help the client understand why the role of the mediator is so different from a judge or an arbitrator. So I will emphasize points like this, right? He's not a judge. The mediator is not necessarily also a subject matter expert, although some of them might be. Classic lawyers' representation submissions are ineffective. So don't hear us trying to quarrel or debate legal issues, for example, so they know it's not a hearing, it's a facilitated negotiation. This is what it looks like. We start at the top, we go to the bottom, but along the way, mediation is a flexible process. So there will be opportunities to break out and do other things. This question of who speaks at which stages is extremely important, and what would be the subject matter of what you're talking about. And all of that leads to, at the end, the client understanding that we're here to do problem solving. And so at the last two slides, you will see that it drills down into brass tacks now of the very case specific manner in which we are going to address problem solving, right? Define what our goal is, what are the major issues, what are the interests, and all of these things, all of us who are mediation slash negotiation trained will know they come from some of those things we've done, like Sally Soprano, right? What are those things that we need to prepare in order to get ourselves to a good point during the course of the mediation process? So I'll stop sharing, but this is something I do so that the client is has a chance to think through exactly what the preparation would look like. And sometimes after this, I'll say, go and think about the answers, right, to some of the questions I've raised, and we'll meet again to prepare.
Okay, that's very interesting, Tat, because having a we see a lot of lawyers, at least in our part, who go straight in for the mediation, but without too much of client prep. And thank you for breaking it down, because it is important to see how it is done. One is to say, okay, you need to prepare the client, and the other is to actually showcase how it is done. So that when you have taken them through this, now is it time to jump in for mediation, or is it that there's another session you do where you're looking at the facts, the options, the solutions? How do you go with that?
So you've seen earlier on that there are those lists of questions that talk about strategy, what's your reservation value, what you hope to accomplish. What I typically would like to do is to ensure the client has answers for all of those things, right? So that when we move into the mediation process, we are all, I use the word align a lot because I want to be sure that as the mediation counsel, as counsel representing the parties, I know exactly what they're looking for when we go into the mediation process. And it helps me because then we don't have to have too many breakout groups or breakout meetings during the mediation just to determine again where do you want to go with this or that. The preparation makes a lot of sense, but some clients I would say are a little bit resistant because they would say, well, isn't this going to result in a lot more fees and so on and so forth. And the way to persuade them sometimes is for me to explain to them that preparation would help them achieve a good outcome, right? The more you prepare, the more you are able to see the spectrum of possible outcomes. And when you move into the actual mediation, you would then be able to move rapidly to a point where you know where the gaps are, and based on our earlier discussions, roll out a strategy to try and overcome those gaps. That's what I think is helpful.
Interesting. So that now your client and you have prepared well, right? You go in for a mediation, but the opposite lawyer hasn't taken time out to prepare their client,
Sure.
right? So how do you work around a situation like that?
Well, if you think about a continuum, right, a spectrum, it's not unhelpful if you are prepared so much better than the other side, because I found that in cases like that, we could go in there, and I think Jonathan and you know that I talk about lawyers who are value creator and value claimer. I could go in there and claim a lot of value for my client because the other side is just unprepared. And so we'll be able to think of the nuances and getting the mediator to work so that we can do our best for our client. And at the end, the client may even have what we talk about in mediation is a win-win, right? We might even get something close to a win-lose proposition. Certainly, I've had cases where at the end of mediation, my client actually extracted so much more than they possibly might not be able to get the same outcome even at an adjudicated hearing. So that's one spectrum. The other spectrum is we, of course, also prepare for cases where the opposing counsel may not be prepared at all, or they might act in a way that tries to scuttle a mediation. So that also forms part of the discussion with the client in preparation for the mediation. So the question would be, if we move into a mediation process and the opposing counsel does this and that, what would be our reaction? And it wouldn't come as a surprise, I think, because we would, at least a week typically before the mediation, know who's the lead counsel on the other side. Having practiced as long as I have, most of the opposing counsel would be people I know. And it wouldn't stop me from giving them a call just to suss out what it's like. And having that phone call, sometimes if it's someone I know well, it gets us into a good place because we know where the perimeters of discussion might be and what are the OB markers. And then moving into discussion, we can then effectively both collectively use the mediator to help understand our respective positions better and help us to bring parties much closer, much faster, especially if the two lawyers know each other.
Yes, I think that's a very, very important point right there, because if there is a possibility of the lawyers communicating before, more often than not, I have seen that the intentions become clear, and when both the lawyers know that there is an intention to mediate and settle, there's a much higher chance that they work with their clients also, accordingly, which is very, very important here. Um, that one thing that I'd love to ask here is, when there is an impasse, right? How do we work around with that? What happens when you are seeing the client, the opposite client, is causing an impasse? Do you speak directly to them? Do you speak to them via the council? How do we break that situation?
Well, again, it's not going to be a binary answer, I'm afraid, because I suppose it depends on the context. And of the many things and the many things that I've done in the past, if I know the lawyers well, sometimes I'll ask to speak to the lawyer directly on a one-to-one. Like, I'll ask Nishant, I'm not understanding what's going on. Can you help me understand why are we reaching this point where we don't seem to be able to progress? Right? If I don't know the lawyer well, then I might go and see the mediator directly with or without my client and say, I'm not sure if we are going to be stuck here for a longer period in time. Can you help us understand what we need to do in order to get past this stage, right? Using the mediator. Or sometimes I would ask the mediator, can you call a cross caucus among the lawyers, because we want to have a frank and open conversation with my learned friend from the other side. And if it's just among lawyers, we can usually speak very openly. And I might say, Jonathan, I'm not sure if we are doing ourselves much favor by just sticking around and having no progress. Here's the deal, and now I'll speak very frankly. My client needs to have this, and we sense that your client is resistant. If that's correct, maybe share with me what exactly is holding up our discussion. Those kinds of conversation can be very effective. And if everything fails, then at my client's end, we'll have a few other tools we can use, right? We might then say, well, if we reach an impasse that doesn't seem to be capable of being easily overcome, despite what we do, then maybe it's timely to roll out a few things for the mediator to help us. One is, to express to the mediator, we are not going to continue unless we see progress. And to help the other side understand where we are, let me give you our next to final number that we are prepared to resolve this matter, so that we at least give them some encouragement that this is where we can go to, right? Or we could ask the mediator to see if he can persuade the other side to do something like bracketing, negotiating within a certain range, or whether, we might want to, if there's some compaction issue we are not aware of, take a break, take an adjournment, and come back another day. So there are many other options, of course, apart from what I've said. But the key, I think, is to be very intentional, be prepared for all of these scenarios. And of course, if you have an experienced mediator, obviously the mediator will be working his or her mind off to try and get parties to close the gap and bring parties closer together.
I couldn't agree more, Tat, on that. And I think the biggest three takeaways, at least for me, here was that one, it is a stage where you take the client through, what mediation is like. Give them the information, let them sleep over it, so that by the time they come next, they're sure whether they want to move ahead with it or not. And they're more well informed of the process. Then it is about preparing the client and strategizing with them so that you're well prepared before going for mediation, irrespective of whether the opposite party is prepared or not, or whether you have a mediator that can assist you well enough as far as the problem is concerned. And the third thing that came out was that if you are able to connect with the lawyer prior to the mediation, it helps in bringing both the parties and pushing the mediation forward. And I think if Jonathan, you have any question here?
Yeah, I have a lot of questions, but please
Okay.
carry on your thought.
Okay. So I just want to understand when we're talking about, we're saying that both of you have, mediated matters as lawyers. You see the benefits of mediation. What is it then that prevents law firms from recommending their clients to go in for mediation? Because Raj, even in India, the multiple conversations that I've had people from law firms say, hey, you know what, we are using it as a delay tactic, or we don't necessarily, we never recommend it unless the court directs us. Why are law firms waiting for court to direct the parties? Why not go in for mediation where they see a possibility?
I think Raj has an interesting take on this. Go ahead, Raj.
So, Nishant, this was probably the scenario maybe a few years ago. Things are changing, and especially in corporate transactions, big disputes, we're seeing a role of mediation coming in much earlier now, even before you go into a litigation zone or an arbitration zone. I think people have realized and seen the importance of a good mediation and to see if it can be commercially resolved. At the end of the day, the parties are in the business of doing business. They don't want to litigate. They don't want to fight, right? So if they see value in it, they will grab it and they will say we will go in for a mediation and resolve it. Like firms like ours or many other firms in the recent past have started to advise clients and suggest that at least consider doing mediation. But many a times it's possible that your clients say that may not be ready to go into mediation at the initial stage. So then you'll have to time the mediation at the right stage, or maybe put that idea or a suggestion to the client at the right stage. But it doesn't mean that law firms do not suggest mediation or negotiated settlement to clients, because I think that's the right way to go. Considering what's going on in India, and considering that it can take years before a matter can be finally heard in courts in India because of the backlog that's there, I think people have realized that if they want to get commercial benefit out of any disputes, or they want to resolve their disputes and carry on with their businesses, it's better to resolve it and not continue fighting.
Yeah, and this
So
kind of
today,
aligns with.
the fact that law firms, in fact, law firms today are actually advising aggressively and actively to parties to consider a mediation as a serious option.
Jonathan, I really want to ask one thing though. It's
Sure.
just mind. Raj, what, and can go to Tat as well. What needs to happen, whether at a policy level, whether at a regulatory, what needs to happen for law firms to actually go in for mediation or recommend mediation as a first choice? What will make it easier for them to do that as a first step?
So I think today, with the amendment to the with the new Mediation Act coming into play, I think that's already a first step taken, right? One, of course, we will have to consider how do we bring in the cross-border mediation into the fold. That's going to be a very important aspect. Third is the awareness and the training, which is extremely important because today you have to make law firms, their clients aware about the benefits of mediation. Other than few lawyers talking about mediation, there needs to be a consistent road shows or platforms like these, which actually bring together actually the stakeholders and make them aware about the benefits of mediation. And once you keep doing that over a period of time, people will go into mediation. See, if you see arbitration, nobody went into arbitration on day one. Nobody went into arbitration when Act came out, right? It takes time. But I think India has already taken those steps. I think today we are already seeing the benefit of people, even commercial people, looking to go into mediation even in commercial disputes, which earlier was restricted to family disputes,
Yeah,
right? Today
absolutely.
you're seeing actually the commercial disputes go into mediation. So you've already taken that step. It's just that it will take some time. It will be important to see some results. It will be important to see how they are tested in court, the enforcement mechanism. Once you have that in place, you will see more and more people accepting mediation. I think that's very, very important. And of course, you'll have to do something about cross border mediations as well as a policy.
Jonathan, I think his screen is frozen.
Yeah.
No worries. So, Tat, I'd then like to ask you, what has happened in Singapore that has incentivized mediation for law firms?
Um, I think it's just a natural progression. I don't think it's very specific to Singapore, but maybe there are some things that's happened here that have encouraged lawyers to hop on the bandwagon. And I say that because maybe closer to 10 years ago, when, just before Singapore revamp its thinking about wanting to be a dispute resolution hub. And along with that came the encouragement from both the judiciary as well as the ministry to create, for example, these institutions that today is like, commonplace institutions here in Singapore, the CIDRA, the CIMI, the SIMC. Uh, in those days, the lawyers were still very averse to mediation, principally because, I mean, there are all so many arguments, right, from the very conceptual, from the very esoteric argument about rule of law and how can you obtain that when people are just negotiating an outcome void of legal considerations, to the question of, well, what about our fees? Because, if we have a book value of a file that's based on, let's say, bringing a case to a trial, which you can actually work out quite well for any given matter, and then mediation comes in and disrupts the whole process, so that instead of every partner being able to determine a book value, say for your ongoing cases, now you have to deal with the prospect that out of, let's say, 10, say, high court cases that's going to go to trial, and each case might yield a fee, let's say, to the firm of, in some of these big cases, easily, 3 to 500,000 Sing dollars for each file, the lifespan of the file. And you work that out, well, every partner who has a book value might say, well, my revenue for my team this year would be in the region of, say, 5 to 10 million, easy, right? Just for the core area of practice. And then you say, let's interpose mediation in, let's say, most of these litigated cases. And what are we talking about? The mediation settlement rate currently at the Singapore Mediation Center is about 59%. It used to be a higher rate of about 73. But even at 60%, what it actually means is it is literally going to halve your revenue for 60% of your files. And that creates, I think, a mindset of fear. Like, is this a good thing? I mean, even from my own personal anecdotal, right? I used to have a partner who was very pro mediation, and he would say, yeah, we should bring our cases to mediation. But the litmus test came one day when, in the quiet room that we had, and I told him, oh, just settle another case at mediation. And he turned to me with that look and say, is it okay if you do less mediation? I was actually taken aback at that moment, because we had gone through a number of years together, and he's always been outwardly very pro mediation. But that was the first time I heard something that didn't resonate. And I suspect that maybe that has all along been his internal process, the struggle between, yes, I want to outwardly be pro mediation, but I also want to have more money, right? More fees. And at some point, you have to, I think, each of us determine where the balance lie, right? And to each his own, I would say. Those of us who relish this practice, we probably will not be making as much money and fees as someone whose practice consists almost entirely of arbitration and litigation trials. But I think it does bring us a lot more, I would say, personal satisfaction in the kind of work we like doing and problem solving to help people. But like I said, to each his own. But those are the two tensions I think that needs to be addressed.
Yes, no. Like I said, I completely agree on that front. There needs to be slowly and steadily an attitude change as well, which is coming by, as Raj mentioned, with the Mediation Act coming in place. It's already coming in, and as users see the benefit, it is going to grow more and more. So, how important then is it for lawyers to be trained in mediation? And when I say for lawyers to be trained, I'm not talking about training as mediators, but I'm saying to be trained as experts who are representing their clients in mediation.
Is this for me or for Raj? I think I've
Anyone
spoken
would
a
like
lot.
to pick it up?
Okay, well, I'll say a few things. I'll hand it to Raj. And I mean, I think that we talk about training um, for mediation advocates. So often we call it as a must, but I think that we probably would do well explaining why that seems to be a no-brainer, right? Uh, if you think about it, would a firm be prepared to send a lawyer to represent a client in a litigation trial or an arbitration hearing without having given the lawyer any sort of training in those processes itself, any kind of training in cross-examining witnesses? It's taken for granted. Of course, you will not. You would make sure that your lead counsel or your first chair, and in fact your second chair, are steeped in this sort of training before you send them out there to represent the client. So why should mediation be any different? And it befuddles me that people would think that you just go into mediation because there's a mediator, let him do his work, we can just sit back and watch things unfold. And at the appropriate time, we will interpose our views, but otherwise, it's all good. And if we don't settle, it's okay because we still have the fallback of litigation and arbitration. I mean, in that sort of notion or principle or idea, I think it's not doing justice to the client. Because I think the kind of mediations I like to work with is parties are very intentional and very committed, and the lead counsel is very involved in going into the process with all the knowledge that he has gathered from training, from practice, from preparation, that when you go in, it is a collective problem solving team comprising the mediator and the counsel on both sides or multiple sides. And all you're there to do for that day or those days that you're in mediation is working as a team to help party resolve their dispute together. And if you don't get there, well, you're back to, as what Raj I rightfully said, to the start, and you go on the adversarial process. You don't lose anything except for having tried something, and usually people do gain, even if they don't settle, because they have narrowed their differences and they know what it would take moving forward. Right. Raj.
Right?
Yeah. So I think training is very, very important. And I think it's very important to not only train the lawyers who are going to be counsels in mediation, but also to have trained mediators, because it's very important that the mediator himself is trained. Many a time we get mediators who have not undergone formal training. uh, they don't know the processes and what it takes eventually. Sometimes you may find mediators trying to push their views down through the parties' views and say that this is something that they should do, but that's not what a mediator should do. He only needs to facilitate the entire process. And therefore, it's important to train the mediators, but also equally important to train the counsels in mediation. Uh, if you have a well trained uh, counsel in mediation, he will ensure that he has had enough time with his client to explain him the benefits of mediation. He will have his buy-in to go into mediation. He will explain him that it is not just a tick box approach, and it is entire process is in a right earnest, right? So the lawyer needs to believe in the process of mediation.
No, I
Lawyer should
completely
be convinced that mediation is the right way to resolve a dispute.
No, I completely agree. The, the being a mediator is a skill, but representing clients as a lawyer is another skill, right? Even if, and as you said, not every time would you get the best mediator possible fit for your case, which is where if the lawyer is trained, he will be able to assist the mediator and therefore the client in the entire process. And I feel, for mediation to grow, or rather for any service or a product to grow, there needs to be a demand, right? Mediation being the service, you need a demand. For the demand, you need users are clients, and the first point of contact of any client in a dispute is the lawyer. Now, if the lawyer is trained and acquainted and buys into the concept, he will recommend, out of 10 cases, not all might be fit, but those four, even if he sees a chance, he would recommend that, to their clients. And if you have a settlement and all four, you're talking about 40% of those cases being settled already. So I think the lawyer plays an extremely important role, as well, equal to having strong great mediators as well.
So I just
I
wanted,
think
I
yes,
just wanted to add one thing
yes,
here, Dushyant. And my thought here is that organization like PACT, and you can probably do that in a very nice way, is to maybe at the law colleges, or the people who are just coming out of law colleges are given this training on mediation. I think when they become experienced lawyers and start advising their clients, when they start believing in the process right from day one, they will grow the entire mediation phenomena, right? So
yeah.
as we say, catch them young, see them grow. You will probably see the same way you catch them young, teach them mediation, the benefits of mediation. You will see mediation grow.
So we'd be the happiest to start somewhere, and that somewhere we'd be happy to start with the associates at Ketan. So whenever you feel the time is appropriate, we'd be more than happy to be there. No, but on a
Absolutely.
serious note, I completely agree. And this is where, even as far as mediation is concerned, when PAC started about 10 years ago, we focused on students, because it's about getting the awareness and understanding of the entire concept. And then, of course, if when you know and understand it, you will make use of it at some stage, as a lawyer. On that note, we have run out of time, and I think Jonathan had a technical glitch. He's not being able to, I think, join in. But it was from his side and my side. It was a pleasure having you both. I know we can uncover so many stories of the matters that you've had. So maybe in future, would love to have you back and dissect the cases in depth. And for all the viewers, I do hope that we take back. There was a lot of take back from this session, and what we have taken back, we try and implement that also. and try at least in the 10, 20, 30, 40 matters that you currently are working on. If you can find out or kind of demarcate that, okay, these are the few matters that can go in for mediation, and perhaps tell your client and work towards a resolution of the dispute. So thank you so much, Raj and Tat. It was a pleasure, and thank you all for joining in with us today.
Thank you, Nishant.
Thank
Thanks,
you,
Raj.
Jonathan, as well. And back. Thank you. Thank you, Ted.
Thanks.